Nicole Koch, and another for hearing. Counsel are now invited to place themselves on record. Please know that this hearing is being recorded.
Thank you. As the court pleases, I am Advocate Ncumisa Mayosi, assisted by Advocate Khanyisa Ngata, both from the Cape Bar of Advocates, and we are instructed by the State Attorney in Cape Town. We are for the applicants.
Thank you.
Justice and Justices, I'm Janet McCurdy. I appear for the respondents in this matter together with Lana Besadenhut.
Thank you. May I also invite Ms. Carstens to place herself on record, please?
As God pleases, Justice. I'm Mr. Renee Carstens from Legal Aid South Africa, and I've been directed by this court to represent the interest of the minor child, Emily Paul.
Thank you very much. I apologize to you, Ms. Carstens, that you did not receive the notification that the hearing today would be virtual, and the fact that you were not able to meet me before the hearing, but that is fine. I'm sure you have been informed of the reason for the delay.
That is correct, Justice.
Thank you very much. For now, we would like to hear the parties' counsel. We'll hear counsel for the applicant first and later counsel for the respondent. At this stage, we are not going to require anything from you, Ms. Carstens. We will decide after we have had counsel on both sides whether we will need anything from you. Thank you very much, but we appreciate your attendance. Thank you.
As a court pleases.
Thank you. Counsel for the applicant, Ms. Mayosi, you may start. I confirm that you are all familiar, that is counsel for the applicant and counsel for the respondents, with the recent directions of the Chief Justice relating to hearings, and counsel for the applicant and counsel for the respondent will be restricted to an address of 30 minutes without interruption, and after that, they may only answer questions from the bench. Thank you. Counsel for the applicant, your 30 minutes starts now.
As the court pleases, Justices. Justices, this is an application for leave to appeal. A judgment handed down by the Supreme Court of Appeal on the 26th of April 2022. I'm not going to repeat all of the facts, Justices, please forgive me, but they're essentially as set out in the judgment of the SCA, which is attached to our application for leave to appeal to this court. The matter, as the Justices will be aware, began in the Western Cape High Court, culminating in a judgment by that court on the 11th of December 2020, which was 3 days after the mother of the minor child to which this application relates had passed away. Miss Heidi Koch, who is the aunt of the minor child, then proceeded to prosecute the appeal. She was granted leave to appeal by Saldana J to the SCA, which she did, and then that culminated in the judgment, which we seek leave to appeal against today. I'll quickly, Justices, just cover the legal principles relating to applications for leave to appeal, applications of this sort. Of course, in order for this court to grant the leave to appeal, the requirements that must be met are well known, and that is that the matter must fall within the jurisdiction of this court, and that it raises a constitutional issue or an arguable point of law of general public importance. And the other issue, of course, being that the interest of justice must warrant the granting of the leave to appeal. In order to constitute a constitutional matter within the meaning of section 167(3)(b)(1) of the Constitution, the resolution of a constitutional issue must be reasonably necessary in order to determine the case's outcome. We submit, justices, that this is one such case. Similarly, this court has held that a case only raises an arguable point of law within the meaning of section 167(3)(b)(2) if the answer to that question is reasonably necessary to determine the case's outcome. A peripheral constitutional issue or arguable point of law is not justification for embarking on a factual reappraisal of a case where the reappraisal is not rendered reasonably necessary by the answer to the constitutional issue or arguable point of law. We submit, justices, that the constitutional issue that arises in this case is the intersection of the paramountcy of the interests of minor children, with which this court, as are all other courts, must be seized, and the intersection between the paramountcy of the interests of the child and the manner of giving credence or applying the objectives of the Hague Convention in such a way that what was foregrounded in Sonder up by in the judgment of Golston J can seek to be achieved. In other words, he spoke there in that case of the interrelatedness or the intersection between balancing the paramountcy of the best interests of the child in a jurisdictional application, and also on the one hand, and balancing that when it comes to the Hague Convention application. So this court, as I've alluded, has consistently held that it doesn't have the jurisdiction to decide purely factual matters, and that is the case even where a lower court has gone badly wrong on the facts. But this court, we submit, can analyze evidence and make factual findings where the determination of such facts is reasonably necessary in order to answer or to give practical effect to the court's decision on the constitutional matter or to the court's decision on the arguable point of law. As I've mentioned previously, justices, the constitutional issue, we say, is raised by the peculiar facts of this case, is the paramountcy of the interests of the child and generally rights of a child to parental care, both of which rights are contained in section 28 of the Constitution. Now, despite the Constitutional Court having adjudicated on various aspects relating to the best interests of the child and the paramountcy of the best interests of the child, we submit that this case nevertheless is rendered unique by the specific facts. The fact that the abducting parent has subsequently passed away after the abduction, while still with the minor child in South Africa, before the minor child could be returned to its state of habitual residence. And another issue which we say arises in this matter is the fact that due to her passing away, of course, the abducting parent is unable to return with Emily, who is the child involved, to the UK. And the difficulty of what weight to give the impact in the short term of the consequences of the mother's death on the minor child in comparison to the weight or the impact in the long term of Emily, the minor child, having been wrongfully removed from her state of habitual residence, with the resultant estrangement, which is well spoken of on the papers, from the custody and care of her only living parent, her father, and her estrangement from the jurisdiction of her state of habitual residence. Another issue which is engaged by the peculiar facts of this case, Justice, is the fact that the second applicant has rights of custody and access to Emily under the convention, and he has parental rights and responsibilities to her in her state of habitual residence. And the person who now asserts the rights to Emily is no longer her mother, but her aunt, who has stepped into a representative capacity for the mother and is prosecuting the matter on behalf of her mother, and asserts an attachment and a grave risk to the return of the child. These issues, we submit, Justices, constitute arguable points of law, calling for determination by this court as a result of the unique circumstances of this case. The question which is pertinent really, and which arises from the unique circumstances of this case is the proper standard or test in the application of an Article 313B defense, the proper standard or test that seeks to implement, for want of a better word, the objectives of the Hague Convention, and to seek the return promptly of children who have been wrongfully removed from their states of habitual residence to those states, and the acknowledgement that, in general, a wrongful removal of a minor child from its state of habitual residence is, in general, accepted to be prejudicial, with the overriding, subject to the exceptions, principle being that the court best placed to determine issues of the merits of custody and access to that minor child are the courts of the child's state of habitual residence. So Justices, we basically submit that there is a constitutional issue which is engaged by the facts of this case, and that constitutional issue is, as I said, the intersection of all these factual issues that arise in this matter with the Section 2028 rights. Now, we of course submit, Justices, that it is in the interests of justice to entertain this application for leave to appeal, as it has good prospects of succeeding, and a submission which then takes us very, very briefly to deal with the merits, and where we say the Supreme Court of Appeal erred in approach. It erred in its consideration of the evidence that was before it, and what we say its failure to consider evidence before it in applying the well-known rule that an Article 13B defense must be looked at with reference to the protective measures that are available in relation to that child in the child's state of habitual residence. And I'll go to the judgment itself so that I can be as brief as possible in the time we have, Justices. I am now in the supplementary record in the judgment of the Supreme Court of Appeal in volume 2 of the supplementary record. I'm going to briefly point out various paragraphs in the judgment and say where we submit, Justices, the court, the SCA, erred respectfully in its consideration of the evidence, and in what we say its failure to consider other evidence in order to comply with the requirement of looking at the evidence before it, but also the legal principle that in circumstances where it has not been shown to the contrary that the state of habitual residences systems, in terms of social services, in terms of administrative systems, in terms of judicial systems, the court hearing such an application must assume that the state of habitual residence and those systems that I've just listed will be able to deal with, to ameliorate the harm to which a child may be exposed by a court-ordered return. The court's judgment, the SCA's judgment, was motivated in large part by the following two aspects of evidence that was before it, and the judgment goes in some detail analyzing the expert reports that were before that court. And in paragraph 50 of the judgment, volume 2 supplementary record on page 163, Justice Zondi just briefly cites from the report of Professor Berg what it is she said in paragraph 4.1, 4.2, 4.3, and 4.4. And that is to the effect, and I won't read all of those paragraphs that I've just referred to, Justices, for the sake of time. But paragraph 4.1, Professor Berg is said to have said, by all accounts, the child is on a positive development trajectory. She has settled into play school. She has friends. She has a primary caregiver, her aunt, and a grandmother whom she now knows. To return the child to the UK would disrupt the positive development in a significant way. Not only would she lose her aunt, but also her nurturing and stimulating environment, and it goes on. The court later on went on to say that there was merit to this opinion or this assertion expressed by Professor Berg. We say the court failed to look at the evidence that was before it in totality in relation to this aspect. The underscoring this opinion, and it's the same issue that is underscoring the opinion of Ms. Pettigrew, is the notion that the child will lose her aunt should the child be ordered to be returned to the UK. What this fails to take sight of is that in her very own report, and I think it's the second report that that Professor Berg did, she was asked a question specifically by the respondents. She was asked the question, in the event that Emily was required to transition into Mr. Ball's care, what length of time would there need to be physical contact, and what should the nature of such contact be to minimize the risk of harm to Emily? That's on page 70 of volume 1 of the supplementary record. She then advised the following. She started by just recording what the sad features of this case were, and what was making this issue particularly complex is that for the past year, the parents of this child have lived on separate continents. She says that, of course, if the same family setup were to have played out in London or Cape Town, the following recommendation would be made. Emily would start visiting her father regularly and with increasing frequency. He would be informed as to her needs and her routines, and he would continue with them. She would still have contact with Heidi, which is her aunt, and the rest of her maternal family, but gradually her father would become her main caregiver. This would take some 2 to 3 months or less, depending on whether the relationship with her father had been a secure one, in which case she might find the transition easier. So in the finding that Emily will lose her aunt should she be ordered to be returned, it does not tally with the fact that in the same report by Professor Berg, she posits a possible transition that could occur that would ultimately allow Mr. Ball to be the main caregiver. And in relation to that issue, we submit that the court, the SCA didn't have sufficient regard to the other evidence that was before it, that had been given by Mr. Ball himself in his replying affidavits, to the effect that if the child is ordered to be returned to him, he has every intention of facilitating the relationship between Emily and her paternal family. This includes her aunt, this includes her grandparents. She has 2 brothers who live in the UK. So the notion that underscores both of these reports, that if Emily were to be returned, that would spell the end of these relationships, is not supported by the other evidence that was before the court, and which we submitted failed to consider. In one of her confirmatory or affidavits earlier on in the High Court, in fact, Ms. Koch herself stated that in the event of a return order being granted, she's prepared to accompany Emily to the UK. She then stated what her means are. She would accompany her to the UK. She states that her anxiety is that she wouldn't necessarily be able to afford to litigate in the UK in relation to the parental and custody rights in the state of habitual residence. But Ms. Koch doesn't fully give the court what her means are and what her constraints are when she makes this assertion, in particular because in the parental rights application, when she was describing her means, she quite freely said that the child, she's able to provide financially for the child would be better off in her care. And she described her means in a manner that does not suggest that she is somebody who would not be able to prosecute a claim in the UK as she should in relation to the merits of custody and care, in the sense that she told the court that she has a property in Northhook that she built. She has other property investments. She also has investments in shares and so on. But she's quite coy insofar as describing what her financial constraints when regard is had to that fuller description of her financial means for the purposes of her parental rights application. So the point I'm trying to make, Justice, is really in relation to this issue, is that Mr. Ball has stated over and over again in his affidavit that he wants Emily to have a relationship with her maternal family. So to equate the disruption that would be caused by a court-ordered return to the UK, to equate that to losing her aunt or a second death, which is what both experts basically describe, is not an approach that acknowledges how Mr. Ball intends to integrate Emily together with her maternal family to the extent that he can, 1, and 2. It's not an approach that also acknowledges that Ms. Koch herself has said that she'd be willing to accompany the child in the case of a court-ordered return, and therefore, notionally, the transition described and posited by Professor Berg could, on the papers as they stand, occur were this to be the case. This, we submit, Justices, was not an issue that was considered in the evidence that was before the court in accepting the conclusion that Professor Berg's report supported the grave risk that was contended for. There are various areas as well, Justices, where the Supreme Court of Appeal relied on a mischaracterization, for its conclusions, on a mischaracterization of the report of Professor Berg. One such instance, and there is more than one such instance occurs in paragraph 51 of the judgment, where Justice Zondi writes that Professor Berg, in her second report, addressed, amongst other things, two questions, namely whether the relationship the father had established with the child prior to his departure from South Africa in October 2019 and the counseling the father and the child would receive in the UK are likely to render the impact of her return to the UK less severe. Justice Zondi then concludes that Professor Berg stated that even if it is assumed that the father and the child had established a secure bond prior to his leaving South Africa in October 2019, and that the Zoom contact with the child since his departure was regular and meaningful for the child. The Justice says, Professor Berg said that this would not render the impact of her going back to the UK less severe. This is in fact not what Professor Berg said. That's an incorrect and material mischaracterization. We submit, Justices, given the conclusions that were reached, because what Professor Berg wrote is that if we assume that Mr. Ball and Emily had established a secure bond before leaving South Africa in October, and assuming that the Zoom contact with Emily during this past year was regular and meaningful for Emily, the impact of Emily going back to her father, to her home in the UK, might be less severe. Not that it would not render the impact less severe. She suggested that it might in fact be less severe. And of course, she supported that or explained that more fully by just describing how a 3-year-old child forms attachments from routines, from consistency of certain activities, such as being bathed, being taken to school and fetched, and so on and so on. Again, she concludes that it would be very disruptive for Emily for her to be returned because of the attachment, and also because that would mean that she's losing the relationships in addition to the loss of her mother, and that could have serious consequences to her mental well-being. I've already addressed, Justices, the notion which we say is potentially a misnomer, that to return the child to the UK would mean that those relationships would be lost. A second material error that was made in the judgment relates to the question of bereavement counseling. Professor Berg was asked if bereavement counseling, if in the event of bereavement counseling being provided for Emily and Mr. Ball, will this ameliorate the risk of psychological harm to Emily? This appears on page 70, volume 1 of the supplementary record, and this is the second report of Professor Berg. The judgment in the essay mischaracterized Professor Berg's response by saying that in relation to the question of the bereavement counseling that would be provided to the father and the child in the UK, the question of whether that would alleviate the risk of psychological harm to the child, Professor Berg stated that bereavement counseling in and of itself could not make up for the loss of the mother and the loss of the relationship that the child had formed since the return of the father. That is not all that Professor Berg said about bereavement counseling. In fact, what she first said was bereavement counseling, if undertaken regularly and for an extended period, would help Emily. It would give her the opportunity to express verbally and in play what she might be feeling. It could also offer father, that's Mr. Ball, guidance on how to respond to Emily's questions and deal with any possible behavior difficulties. She then, of course, said, if it's not done sufficiently, she qualified that. She said, in and of itself, it doesn't make up for the loss of her mother, and a once-a-week hourly session cannot counter the trauma, and it's the equivalent of putting a small plaster on an open wound. But there's nothing on the evidence that would suggest that bereavement counseling that is going to be provided in the UK, should the child return to the UK, is not going to be done with the sufficient frequency it requires so that it translates into a plaster on a wound. The point I'm trying to make, Justices, is that, in fact, in general, Professor Berg's opinion was that bereavement counseling would work. She qualified, but it has to be done in the right way. Now, a deficiency in the approach followed by the experts is the following. Besides the report of Professor Berg, which when she was asked to address that issue, spoke to the issue in general terms of bereavement counseling, is that both reports don't talk to...
Ms. Mayosi, you are left with 5 minutes of the 30 minutes. You may proceed.
As the court pleases. Both reports do not talk to the evidence that was before the court, and neither does the court sufficiently, we submit, in relation to the support mechanism. The reports don't analyze what the judicial support and judicial response, the administrative response, and the social services response, and how the conclusions reached in those reports could be affected by the potential ameliorative effect of the existence of those services. And Mr. Ball went at length in his affidavits to describe his challenges that he had, to describe the environment that Emily would be going to in terms of his personal circumstances. But he also described, there was also a report from the UK Central Authority which spoke to the fact that the mother would have some standing in the UK to in fact pursue a contact application in relation to Emily. She might have to seek leave to bring such an application, but she would not be disqualified from doing so. So she would not be shut out and closed out entirely by virtue of the fact that a court-ordered return had been ordered. There were various other reports that described quite fully what would happen in the UK, what the situation would be, Mr. Njini being one of them, the case notes that were available, that were made available by Emily's late mother to the court, also described, in essence, the fact that there was a relationship between Mr. Ball and Emily before. He took care of the child when the mother was suffering from postnatal depression. The case notes demonstrate that there were, as well as the late Miss Colleen's affidavit, they also demonstrate that there were periods when Mr. Ball would spend every single weekend with this young child. It would change to alternate weekends, and that he was in fact involved and had a bond with this child. Granted, it was compromised. It was compromised, we say, primarily by the wrongful retention of the child by Miss Koch. The question really that must be engaged with justices is whether an abducting parent must be allowed to rely on the consequences of the wrongful act in order to found grave risk. And we say that's not the proper approach in relation to an Article 13B defense. And that in essence, that is what this case is about. Had Ms. Colleen returned to the UK as she had said she would, as they had agreed she would, when she learned that there was no further treatment that could be done for her, she would have returned in November 2019. And this entire period or the child would have returned in that time. And this period of during which the attachment has occurred would not have occurred. This is a direct consequence of the wrongful retention and removal of the child in retention in South Africa.
That is the end of your 30 minutes, Ms. Mayosi.
As the court pleases, Justice.
Thank you. The justices may put questions to you now. With regard to the report of Ms. Carstens, is my reading of it correct that it does not appear that it does not seem to reflect much of any conversation that she may have had with the father of the child?
Justice, let me just.
Is my understanding of the report correct?
Justice, I have to admit that we have not been furnished with the report of Ms. Carstens. The only report of the legal representative that we have is the much earlier one by Mr. Nduli.
Oh, okay.
Yes.
Okay, all right.
It would seem that from what I'm told, that the report of Ms. Carstens was given to the state attorney sometime this year, but the council team have not had sight of that report. So I'm afraid, yes.
Yes, okay, all right. Thank you. The justices would have questions for you,
Thank you, Chief Justice. Okay.
Justice Matlanga.
Thank you, Chief Justice. Ms. Mayosi, you emphasize the uniqueness of the facts in making submissions on jurisdiction. It is so that some facts may be similar in different matters, but by and large, facts in different matters differ. So I'm not finding the submission about uniqueness all that compelling. Do you want to make any submissions in that regard? What should then happen, to the extent that there are differences? You then just apply the existing legal principles to the facts, regardless of the fact that they may differ.
Yes. Thank you, Justice Matlanga. Our main submission in relation to the facts and the constitutional issue and jurisdiction is that because of the facts of this case, it then implicates the constitutional rights set out in Section 28. It then, and that's the basic sort of central submission to us, that the facts implicate that right. Where we say the uniqueness of the facts comes into play is that it raises arguable issues that should be determined by this court. The main issue, which the nature of these facts really raise, is the following: is in what instances and based on what evidence is an abductor of a child wrongfully against the Hague Convention to be permitted to rely on that conduct to found a defense of grave risk? What evidence needs to be before court in order for that to occur? And we say that on the facts of this case, there was not sufficient engagement by the judgment that we're seeking leave to apply against with the totality of the facts. And had that occurred, a different result would have eventuated. And it is an issue that needs to be engaged with, which is how high is the bar?
All right. Then you repeatedly emphasized the Supreme Court of Appeals' failure to assess evidence in a particular way. You are aware of the principle that an appellate court does not readily depart from factual findings made by the court against whose decision an appeal is being brought. Why should we concern ourselves with the extent to which the Supreme Court of Appeal assessed evidence in this or that other way?
Justices, it is an issue of concern in this court precisely because we submit that the standard that was set in Sonda Up for how the paramountcy of the best interests of the child should be given effect to in an application such as this. And it's the facts really on paper, which engage, we say it's a question of interpretation. It's the facts on paper, on affidavit, which should have been applied or interpreted in a particular way in their totality in order to give effect to a right which this court ought to be concerned with maintaining the paramountcy of.
Then you also, correct me if I'm wrong, you seem to accept that in deciding not to order return based on Article 13B, the Supreme Court of Appeal was exercising a discretion. Do I understand you correctly?
It was indeed exercising a discretion in terms of the Hague Convention.
Yeah. Does the fact that we are in the context of the Hague Convention mean that we apply a different test with regards to how an appellate court departs from a decision of another court which was exercising a discretion? Isn't there a particular test for the appellate court to depart from the earlier decision?
Being if
And
the
if
discretion,
so, yeah, yes.
being if the discretion was not exercised judiciously.
Judicially. I think I might be wrong. Ms. Mayosi, but I think so, yes.
Yeah,
I'm raising this. Yeah, you're quite right. That is what the test is. Now, I've not heard you once refer to that test, which is why perhaps with a bit of diffidence, I'm asking, is this perhaps because we are in the terrain of the Hague Convention? And if that is so, why is that so?
This, I would posit to say that is because we are in the terrain of the Hague Convention. And the reason for that comes from paragraph 30, I think it is, of the Sonda Up case, where one of the central principles in a case such as this, and I think it was repeated in Penelo by the SCA as well, is that it would be wrong for a court hearing a Hague Convention application to turn those proceedings into a determination of the merits of custody. And what we submit in relation to the approach adopted by the SCA in its assessment or lack of assessment of the totality of the evidence is that in effect, that had the effect of turning the proceedings into a determination of custody. And it failed to have sight of the test that was set out in one of the cases cited by in G versus D, which is a case that was cited by the SCA itself in its judgment, I think in paragraph 46, which is that there is a it's well established that courts considering applications such as this and considering Article 13B defenses, they should accept that unless the contrary is proved, judicial, social, and administrative authority of the requesting states should accept that they are adept at protecting the rights of the child. Now, the approach that was followed by the SCA, and this being a Hague Convention matter, where the injunction is to have an eye and be satisfied based on all the evidence that the authorities of the requesting state can ameliorate the risk. The effect of doing so is that it then becomes a custody exercise.
Lastly, Ms. Mayosi, thank you. Lastly, the respondents have referred to, or the respondent in her two capacities, has referred to the case of Re-D. And from that case, I get the distinct impression that the fact that a child has been in the state where they have been abducted to for a long time and has established herself, if I may put it that way, there with all that is around her, the relations she has formed, the people she is with, etc. It becomes quite a weighty factor. This is what the case says. The assumption on which the remedy of prompt return proceeds is that the state to which the child will be returned is the state of his habitual residence. Through no fault of his own, the child whose return is being sought in this case has now been settled for so long in this country that this assumption, and I emphasize this last part, this assumption is scarcely tenable. What would your comment be in this regard? Because even here, when Emily left, she was only, what, 2 years, 2 months old? And she's now close to her, is it her 6th birthday?
Yes, in July.
Thereabout. Yes, yes. And so basically, when she was 2, she was very young. Yes, she was aware of what was around her, but not as much as she is now, much, much older. And in your and my language would say, "Sele abukile kangangoko" these days, you know. Colleagues, I'm just translating, basically translating exactly what I've said. So in her case as well, one could easily say that that assumption, return her now, is quite tenable. What's your comment?
I think the case that Justice Madlanga is referring to is LD versus Central Authority, and that's a recent judgment of the Supreme Court of Appeal, which, if I'm correct, involved a mother who had removed 2 children from Luxembourg and brought them.
No,
to
this was a removal from Romania to the UK.
I see. Oh, yes. In that case, in fact, Justice Madlanga, a return was not ordered, and that is stipulated in the judgment of the SCA itself. Where I really want to go in relation to that issue, Justice Madlanga, is in general, of course, the facts of each case and the circumstances are different. A child may be retained for a while in in the state to which the child has been removed. But if circumstances are such that the child hasn't settled, the child could still be ordered to be returned. And it depends on the behavior of the parents and the abductor. And it is driven also by the circumstances to which the child is going to return. So it's not always automatically untenable to return a child, simply by virtue of the fact that the child has stayed in the requested state for a long time. Now, the issue of settlement is provided for in The Hague, where Article 12 talks about if the judicial proceedings are instituted within a period of 12 months from the removal, or after 12 months from the removal, then the onus shifts and the child is said to have settled, and it becomes a much more difficult road to get the child to be returned. But it's still not unheard of, even there, for a child to be returned to the requesting state.
Thank you, Ms. Mayosi.
Ms. Mayosi, thank you. Ms. Mayosi, if I can follow up on the questions relating to jurisdiction, which my brother Justice Madlanga had engaged you on. Is it correct, is my understanding correct, that essentially the applicants are asking this court to determine whether Article 13, the Article 13B defense is satisfied?
Whether the SCA applied the correct test in coming to the conclusion that the Article 13B defense is satisfied.
Now, when you refer to the correct test, this court has held that the misapplication of a law does not give this court jurisdiction.
Justice Tron, I want to submit, and I don't have the authority at the top of my head now, that if the misapplication of a law engages a constitutional issue, if the fact of the misapplication of a law engages a constitutional issue, the jurisdiction of this court is engaged. I don't know if the circumstances that you describe are similar to the judgment in the Tembisa case, which had to do with medical negligence, where Justice Rogers, in his judgment, wrote that it was purely factual, and the fact that it was purely factual didn't engage the jurisdiction of this court. Also in Jiba, that was a similar finding, that the jurisdiction of this court was not engaged. I would submit, Justice Tron, that if the misapplication of that law engages constitutional rights, impacts constitutional rights, this court's jurisdiction is engaged.
Is it the applicant's argument then that every matter that implicates the best interests of a child raises a constitutional case or constitutional matter?
Every matter that implicates a child, the paramountcy of the best interests of the child, in fact, I would say it implicates the jurisdiction of this court.
Wouldn't a party need to show more? For example, and I'm thinking out loud, in this case, wouldn't the applicant need to show that the SCA, in its interpretation or application of the convention, violated the best interests of the child? And perhaps I'm missing something, but I have not seen that come through in the applicant's papers.
Perhaps not in that greater detail, Justice Tron, I will concede. Safe to say that in our application for leave to appeal, what we stated is that the paramountcy of the best interests of the child are implicated by the judgment of the SCA that we're seeking leave to appeal against. But the effect of what it is that we're arguing is that the issue, which is a matter of public interest, which that judgment has then invoked, are the questions which I alluded to earlier, which include the test in circumstances such as this. What test is to be applied for grave risk where the person retaining the child seeks to rely on the consequences of that retention to found jurisdiction.
That your answer then takes us to the first question that I'd asked you, Ms. Mayosi, about whether the applicants are saying that the ACA misapplied the test. Now, there's a difference between constitutional jurisdiction and the extended jurisdiction. Whether it's an important point of law that needs to be determined. What is your submissions on that, Ms. Mayosi?
What we submit on that is along the lines of the Paulson judgment, which is that the judgment of the SCA, insofar as it engages the Constitution and the manner of dealing with Article 13 defenses going forward, it raises issues that are important issues of law that need to be determined by this court, that call for the proper determination by this court. And we say that it's in the interest of justice for this court to deal with those issues. Of course, and in support of that, we say because these issues have to be determined and we have prospects of succeeding in the appeal.
That would fall under the extended jurisdiction of the courts, is that right?
Correct, Justice Theron.
Now, if we go that route, given that this is a highly factual matter, as was also pointed out by Justice Malanga, on what basis can this court interfere with the factual findings that have been made by the Supreme Court of Appeal? And in your address, your protected address to us, you spent a long time dealing with the facts of the matter and making submissions as to where the Supreme Court of Appeal had gone wrong, in particular in disregarding some of the facts and some of the reports, contents of the reports.
Correct. Can you repeat the question, Justice Theron?
Yes. Now, given that this is a highly factual matter, that it's fact-based, on what basis, in exercising our extended jurisdiction, can this court interfere with the factual findings made by the Supreme Court of Appeal?
The determination of the very test requires this court to go into the facts that were before the Supreme Court of Appeal and that are before it. The determination of the question of whether or not the determination of the issue that arises here and its intersection with the Constitution, what we say is the constitutional issue, requires this court to engage with whether or not the SCA applied the standard correctly and whether a new standard a new test ought properly to be developed for the purposes of the Article 13B defense.
Thank you, Ms. Mayosi. I have a few other questions which I will pose later, but those are the only questions I have on jurisdiction. Thank you. Thank you, Chief Justice.
Can I ask, sorry, CJ?
Yes, no, I just want to say, colleagues must feel free to ask questions on all aspects so that when we are done with putting questions to her, we are done with that part of the matter. Justice Majid.
Yes, thank you, CJ. Ms. Mayosi, one of the matters that exercise my mind in this case, and which may very well, I'm not saying it does, but which may very well engage our extended jurisdiction is this. The Hague Convention and the Section 28(2) right in the Constitution has to be juxtaposed against each other. Excuse me, and that brings in the question of onus. What would be the onus in a case like this on a party that utilizes an Article 13B defense? I ask that because the question was pertinently left open by Goldstone J in the case which I must mention, which is for the protection of the minor, and all the other cases are, and I think this one should be too, cited as S versus T. At paragraph 44, Goldstone J raises the question of that judgment that Sonderap at S versus T, as I says, whether in the light of the provisions of our Constitution, our court should follow the stringent tests set by courts in other countries. And he cites some of those cases in the footnote 41 from Australia and from Canada and so on, and Germany. Now, this is my question. What should the standard of proof be? Should it be the ordinary balance of probabilities in a civil case, or should it be a more stringent test as employed by other jurisdictions? And then secondly, what onus did the SCA in fact apply in deciding this matter in favor of Ms. Koch in raising the Article 13B defense?
The question of onus, Justice Majid, as I understand it from the jurisprudence, differs slightly from the question of whether to give a restrictive interpretation to an Article 13B defense. The onus, as I understand it, is on a balance of probabilities, but the threshold for establishing that defense, the factual threshold for establishing that defense, is often said in accordance with overseas jurisprudence. The threshold is quite restrictive. So in general, as I understand it from the jurisprudence, the onus is on a balance of probabilities, but it's generally not a defense that is easy to establish.
That leads to the question, what test did the SCA apply? And because it was left open in S versus T, this particular aspect, is this a matter that engages our jurisdiction, and why?
Justice Majid, not at the risk of repeating myself relating to why it is that we say this is the matter that engages this court's jurisdiction. The Supreme Court of Appeal, I think, applied the onus on a balance, the civil onus on a balance of probabilities. What we say as part of our argument, which is why we say they didn't look at, they didn't give or consider sufficiently all of the information that was before that court in relation to this particular defense, is that they did not then turn to sufficiently, with respect, turn to the mechanism that are available in the requesting state to ameliorate the risk of harm from a court-ordered return. So the effect of that, we submit, is that the approach that they followed was it did not sort of follow the accepted approach that if there's harm that's been established and it's grave enough, it must be a serious harm. In fact, it must not be just a serious harm. It must be harm which is more than the ordinary harm caused by ordinary disruption caused by a court-ordered return. So it must be harm of a certain threshold of seriousness. So if harm has been established, the graveness of that harm is that measured against what the situation that the child will find, the totality of the situation that the child will find when the child is ordered to the requesting country.
Thank you.
And
sorry, okay, conclude. I have one last question, but conclude, please.
yes, and so our submission is that there are material facts that were before the SCA that it did not consider in order to establish in totality of what was before it, whether or not the child would be, the harm facing the child would be capable of amelioration in the UK.
Well, all I can say is the response you're giving me now is exactly the dilemma that you have that has been enunciated by my colleagues, Justices Madlanga and Theron. But let's move on. What you are basically engaging now is for this court to sit as an arbiter of facts. But let me ask you also related, but on a somewhat different level. You've been asked about the question of the exercise of a discretion and an appellate court's limited room to interfere on appeal with that kind of exercise of a discretion. If it was, the only question is whether it was done judicially. Can it be said that the exercise of this discretion, well, I think you make the argument in your written submissions that what the SCA did here in exercising that discretion was tantamount to a custody determination, which you say is inimical to the convention. The convention says you are not to determine custody, but it's a jurisdictional issue. So I want to ask you, is there an argument, is your argument that this exercise of discretion amounted to a custody determination, which the Hague Convention said you shouldn't enter into? And if so, what is the status then in that scenario of the pending Western Cape Parental Rights and Responsibilities application in terms of the Child Care Act? Thank you.
The parental rights application has been pended until the final determination of all appeals here. Now, what we submit, and when the difficulty we have with the approach that was followed, and why we say that the approach then in essence had the effect of the issue being a custody determination. The request, the court considering an application is required to interpret an Article 13B defense in such a way as to give effect to the purposes of the convention. The main objective being that the court best suited to determine these issues of custody are the courts in the state of habitual jurisdiction. Now, the manner in which this particular matter was litigated, it sought to promote a narrative on the papers that said the one person is a better parent than another, which is not a determination that courts here ought to make. That's a determination that ought to be made elsewhere. So the difficulty we have is that in failing to give proper consideration to the evidence that demonstrated how to ameliorate this harm in the UK, it doesn't give effect then to the convention in that way. And the matter ends here, in effect, saying that one person is suitable to parent than another parent, in effect.
Just to clarify, are you then saying that is not a judicial exercise of the discretion by the SA? Is that your submission?
The failure to consider evidence before it, that is the submission.
Thank you. Thank you, CJ.
Thank you. I don't see any further indications from colleagues.
CJ, sorry.
Okay, Justice Rogers.
Yes, if that was going to conclude the applicant's address, I just thought I should say that, at least for my part, Ms. Mayosi, I think it is important that you should obtain and read Ms. Carston's report, because we will need to decide whether we take it into account and what weight to attach to it.
Yes.
So I would recommend that you get it, and through the CJ, perhaps deal with it in reply or in some other suitable way.
Thank you.
Yes, I think that would be quite important. So it may well be that because it's a report that 26 pages, it might not be a report that she can read and do justice to on a 10 minutes, 15 minutes break. It may be that we'll have to talk about whether she would do so by way of written submissions, or whether she would get a chance to do so later. Okay, I think for now, let's leave it at that. And when we break for lunch, I will hear what other justices think about that. And then during the lunch break, we can send a message through the clerks to counsel on all sides with regard to what the position will be. Okay, I think Justice Van Zyl, you might have a question.
Yes, thank you, Chief Justice. You'll see, on my reading of Article 13B, it raises two aspects. The first is a finding with regard to whether or not there's a grave risk that the return of the child expose the child to physical or psychological harm, or otherwise place the child in intolerable situation. That seems to me to be a factual inquiry, and that once the court has made a finding with regard to the risk or the existence of the risk, as you have made the submission and you have support for that submission in various decisions, that they then vest a discretion in the court to refuse to order the return of the child. What I want to know from you, what are the interests or the considerations that a court should consider when exercising that discretion? And in the context of this matter, which facts should be considered in evaluating the weight to be given to each one of those considerations? I might just add that you refer to the standard or the test that needs to be reconsidered. It seems to me that you are, in fact, dealing with exactly this aspect as to what the general interests are or considerations are that the court should consider or weigh when it exercises its discretion. And it is not an aspect which I find has previously been dealt with in any of the decisions. And in fact, in the case of Sonderup, the court seems to have left this whole aspect open when it said in paragraph 18 that it's not necessary to decide in this case the precise implications of the language used in the subparagraphs of Article 13. So if that is so, is this not a matter that engages the jurisdiction of the court? I've actually asked you quite a few questions now, but let's first deal with the jurisdictional aspect, and then if you could possibly identify what those primary interests or considerations are, and then return to the facts of this case.
Thank you, Justice Mansell. I hope I'll get all the questions that you asked. So when you're correct that Article 13B, which is the one that we are particularly seized with, this exception, involves an allegation of grave risk. What the courts have said, of course, in describing this risk, and that's the debate that I had earlier as to the differentiation between onus and threshold, is that Australian and Canadian courts have, to some extent, UK courts have tended in general to give it a restrictive interpretation in that the risk must be grave one. It must not be a risk that follows from the normal disruption of a court-ordered return or the unpleasantness of removing someone from South Africa.
Ms. Mayosi, sorry, can I interrupt you? The question doesn't deal with the first part of the article. It's based on the assumption that the court has found that a grave risk does exist. It then deals with the issue of the discretion. And I want to know, when you exercise the discretion following upon a finding that a grave risk has been established, on what basis do you exercise that discretion? And isn't that the issue that should engage the jurisdiction of this court?
Correct. So once Justice Van say the getting to a conclusion that the risk is grave involves a forward-looking exercise of looking at the circumstances to which the child will return. And it must be assumed, unless the contrary is proved, it must be accepted, not assumed, unless the contrary is proved, that the UK's administrative, social, and judicial services will be able to ameliorate that risk. Another principle which is engaged in this case is that an abducting parent should not ordinarily, I think I've said should not ordinarily be permitted to rely on the consequences of their wrongful conduct in order to found the risk, which we say is a factor in this case, which we say is a question which this court ought to engage with. Because if Justice Van Zyl will recall, the late Miss Collin knew and or decided or changed her mind in about November 2019, when Mr. Ball had left the country in October 2019. So the time, if the agreement that they had been implemented at that time, the risk might have been looked upon differently, but the time factor, and which is a direct consequence of the wrongful retention, now forces the court to engage with the question of, in what instances can one rely on their own conduct to say there's risk, and should it be permitted? And does that accord with the objectives of the Hague Convention?
So as I understand you, what you are saying is that one has to have regard to the objects and the purpose of the Hague Convention. And then one should also have regard to the nature of the risk and how you can ameliorate the risk. And then I think the other aspect that you've mentioned in your address is the interest of the other parent. And in this case, it's the only surviving parent with rights of custody. Are those your submissions?
Correct. Correct.
Thank you. Then the other aspect, I want to return to the first part of Article 13, and that is the existence of a grave risk. You have in that context, you've dealt with the evidence of Professor Berg in her initial report and later in her supplementary report. But it's evident from the judgment of the SCA that it also relied on the evidence of Ms. Pettigrew. And Ms. Pettigrew in her evidence states that there's a high probability that a loss of two primary caregivers in the absence of a bond with a nurturing parent will lead to a psychosis and emotional and psychological damage to Emily on the long term. What must we make of that evidence, and does that not constitute a grave risk as envisaged in Article 13b?
In order for that conclusion cannot be made in isolation, that opinion cannot be expressed in isolation, we submit, without considering all the submissions or assertions made by Mr. Ball regarding his personal circumstances. We accept that there's a risk to make an opinion of a permanent or a serious psychosis in the absence of considering the support services which the evidence speaks of in the UK. It's not just bereavement counseling. There is early support for parenting, for bereavement, and there's a whole team that gets in. And this family was known to the support services in Herefordshire since 2017 and have been engaging with their various difficulties. So the submission we make in relation to both reports is that the reports didn't assess what is available in the UK to support this child, but conclusions were reached without engaging Mr. Ball, without engaging that issue. Because if, and we accept that the whole situation is going to, and the experts accept that, is going to cause Emily to have to deal with the issue of the loss of her mother over time. I think there's even a suggestion that now she doesn't even have the full appreciation of it yet. But to conclude that way without assessing the totality of the support services that are there to ameliorate it falls short, we submit.
Yes, thank you.
Ms. Mayosi, assuming that the Supreme Court of Appeal exercised discretion in concluding that the child's aunt had established the Article 13b defense, would that mean that the High Court, which came to the opposite conclusion, had also exercised the discretion in dealing with that issue, or would it mean that it did not exercise discretion?
It had exercised a discretion. The structure of Article 12 and 13 requires a discretion to be exercised upon a consideration of of various factors.
Are you able to make a submission on whether or not, in arriving at the opposite finding on this issue, the Supreme Court of Appeal observed the limits that are imposed on an appellate court in dealing with a decision on appeal that was arrived at by a lower court in the exercise of a discretion?
The court being a court of appeal, the SCA, would have been bound by the record that was before it. The High Court would have been bound by that record for different reasons, which is that it was in motion and so on. So in arriving at a different discretion, the SCA reasoned that for the reasons advanced by the mother and those alluded to by the experts, the High Court was not obliged to order the return of the child to the UK, as the mother had succeeded to establish that the return of the child would expose the child to risk. So what correctly happens is that if the parent fails to establish an Article 13B defense, then in fact, the High Court was in fact obliged in the absence of a proper defense, because Article 12 would then have been engaged, because the proceedings were instituted within a period of under a year from the time of abduction. So.
Okay, I'm not sure if you understand my question. Maybe let's start at the beginning. Was the High Court required to exercise a discretion in determining whether the aunt had established an Article 13B defense or not?
Yes, the High Court was required to establish, in determining that issue.
Yeah.
But having determined against the mother on that issue, it was then obliged to order the return.
Yeah, but I'm asking the question, was it required to exercise a discretion, or was it not required to exercise a discretion in determining whether an Article 13B defense had been established?
It was required, I think the Article 13B states in terms that, notwithstanding the provisions of Article 12, the judicial authority, being the court is not bound to order the return of the child if the person who opposes the return establishes that an Article 13B defense is established.
So what is the answer to my question?
So there was, it would have, I would have to submit, Chief Justice, that the exercise that the High Court had to engage in was to find out on the facts whether it had been established that the child would be exposed to grave risk. It's a factual exercise applying the principles I've alluded to, which is there is a risk, yes, but it's only grave if it can't be ameliorated in the requesting country. It's a factual determination.
So at what stage does the discretion come in?
In the determination of an Article 13B exercise?
Yeah. Is there room for a discretion there, or is there no room? If there is, at what stage does the discretion come in?
The way that Article 13 is structured, it suggests that if a factual finding is made that there's no grave risk.
Okay, let's start. Let's look at it this way. We have got A and B under 13. Is that right?
Correct.
Article 13. And before that, the article says the judicial or administrative authority, let us say here the Western Cape High Court, okay, is not bound to return the child if, I'm now putting it in my own words, or if the person, not in my own words, or institution or other body which opposes its return establishes that. So in other words, if any one of these two situations exists, A or B, as I understand it, then the Western Cape High Court was not bound to order the return of the child. Would my understanding be correct that not being bound didn't mean that the court would not necessarily ultimately order the return, but it would mean that it's not bound, it is free to take into account whatever relevant factors. It could still say the child must be returned, but so there would be a discretion. Is that not correct? That if there is no A or B, it would have a discretion, but it would not be bound to order the return.
If there's no consent that's been established to the retention, or there's no grave risk that's been established.
We are looking at A or B.
Yes, the court is bound. If there's no consent that has been established, or a grave risk that has been established, that's B.
Yeah.
That then the court must order, because then that takes us back to Article 12, if the jurisdictional facts of Article 12 are in existence.
Yes, but on your submission then, at what stage did the High Court have a discretion, if it did have any, either to make a finding or to make the order that it made?
The High Court stated that the Article 13B defense had not been established.
Yes.
It found that it hadn't been established. It also found that 13A had not been established. So
And let's stop there.
Stop there, yes.
What was the effect of that on what order it could make?
It had to order the return of the child.
It was bound.
It was bound, because then it takes it back to Article 12.
It did not have a discretion.
It didn't have a discretion.
So you say the High Court had no discretion, but the Supreme Court of Appeal did have a discretion. How does that work? Did the Supreme Court of Appeal have a discretion?
Yes. So the Supreme Court of Appeal found differently. It found
that B existed.
That's right. It found that B existed.
Yeah. And in that case, did it have a discretion or did it not have a discretion?
It has a discretion if you read how it's worded.
Yes.
It's not bound to return the child, whereas 12 makes the High Court bound. But here it's not bound if somebody consented in terms of A, or there's a grave risk that's been established in terms of B.
Okay, all right. Now, therefore, on your submission, there was a discretion that arose in the context of the Supreme Court of Appeal, which did not arise in the context of the High Court because of the finding it made.
Correct.
Now, the requirement in B that there must be a grave risk that or his or her return would expose the child, blah, 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 blah. Whether there's a risk, maybe that might be factual, but whether the risk is grave, is that factual?
It's informed by the following. There's a risk that must be identified, and the Supreme Court of Appeal must then engage with the question of whether that risk is grave. And it's now considering this as a court of appeal. It now considers whether that risk is grave with reference to, at a level of fact, the circumstances that the child is going to be ordered to, in order to get to a conclusion that it's grave or it's not grave.
Could it be that whether or not the risk is grave is a value judgment that the court must make as opposed to a factual conclusion of finding?
I would have to submit, Chief Justice, that it's if you look at the standard, that if you consider the standard that has been set, say in G versus D, and which was referred to, and the 6 elements, it was referred to in paragraph 46 of the SCA judgment. The manner in which that it sort of sets out the guide map for that determination to be made, which is look to the future. It must be grave and not be your ordinary tumble and rumble and tumble of being returned, and so on. So it's informed by facts that are before the court on these various aspects.
Yes, but the question is whether it itself is factual or whether it is a value judgment. When you say something is grave, is it a factual conclusion or is it a non-factual conclusion?
I submit that it's both, has to be both, because one must be informed by the other.
When you say there are reasonable prospects of success, is reasonable, is the conclusion that the prospects are reasonable, factual or non-factual?
It's non-factual.
So what is it?
In relation to
yes. Okay, all right. Thank you, colleagues. Is there anyone else who has questions for Ms. Mayosi?
I have one question with your leave, please, Chief
Yes,
Justice.
thank you, Justice Taron.
Ms. Moisi, the ultimate purpose or the main objective of the Hague Convention is to restore a child to their habitual residence. Is it possible that that objective can in certain circumstances be in conflict with the best interests of the child principle in terms of our constitution?
Yes. It's a balancing exercise from.
Yes, please proceed. I'm sorry to interrupt you.
So there are short-term best interests of the child, which are determined in the current application in the requested states courts. And there are the long-term best interests of the child, which are determined, which the principle of the convention says are best determined by the court of habitual residence. So it's a balancing exercise. And there is an acceptance that in a certain instance, and that's why there are these exceptions in Article 13 and in Article 20, that returning the child to the habitual state of residence may not be in the interests of that child.
In cases where there might be a conflict or between the Hague Convention and the constitutional principle of best interests of the child, what would take precedence?
I think that the dicta in Sonderab says that there is no such conflict, because that right can be determined. Sonderab, one of the issues was challenging the constitutionality of the Hague Convention on the basis that it infringed on certain rights relating to the best interest, the paramount. So, and the Goldstone J, writing for the court there, said the exceptions that are built into the convention cater for that instance.
Thank you, Ms. Maria.
So in principle, there's no conflict from the one to the other, because there are exceptions that are built in to cater for the instance where it's not in the best interests of the child to return, all things being considered, to return the child to their habitual state of residence.
Thank you, Ms. Mayosi. Thank you, Chief Justice.
Chief Justice, I just have one question. Thank you. Sorry, Chief Justice.
Justice is muted.
Wait. Oh.
I'm sorry. Is it Justice Kolapen who wanted to ask questions? I'm sorry, I was muted. I didn't realize.
Sorry. Thank you, Chief Justice. Just one question, Chief Justice. Thank you.
Sure.
Ms. Mayosi, you concluded your address by posing the question, can an abducting parent rely on the consequences of its act of abduction to support a conclusion of grave risk? You didn't answer the question, but I imagine you would want us to answer the question in the negative, in saying that it cannot. You're not in agreement.
Correct.
That being the case, how does one then properly conflate almost two conflicting considerations? Because on the one hand, one is dealing with the conduct of a parent who was since deceased in this case, that for the purpose of this argument was in violation of the Hague Convention, while on the other hand, one is dealing with almost a separate inquiry with regard to the existence of a grave risk and what that existence must mean for the best interests of the child, which I think in Sonderab Goldstone J regarded as almost ameliorating the effects of 13B. So I got the sense from reading Sonderab that the paramountcy of the best interest was almost used as an argument by the court in coming to the conclusion that the act was not inconsistent with the Constitution. So how does one square this up in the light of your opening remark that this case is indeed about the intersection between the paramountcy of the best interest and the manner of applying the Hague Convention, given that one is really attempting to impute the conduct of the abducting parent to, as it were, a determination of grave risk. And I see the connection between the two because the English cases speak of the disquiet about allowing that to happen. But in our context, 28.2 might provide a dispositive answer to that. What do you say, Ms. Mnyosi?
Is it, your question, Justice Colopin, seems to talk to the unique facts of this case, which is that the abducting parent whose conduct is sought to be corrected, as it were, for want of a better term, is now no longer there.
Well, not necessarily. I'm simply alluding to, as a general principle, the conduct of an abducting parent might be grave and it might come in for criticism, but one should be careful that it should not unduly impact on the determination of what constitutes a grave risk. That's all. Yeah.
Correct. And I think in its recent judgment in the LD case, that's what that's how the SCA balanced it, in the sense that the case I alluded to about the abduction from Luxembourg, the court spoke harshly against the conduct of the mother in the abduction, but ultimately came to a conclusion that on considering the conspectus of the factors in relation to this child, the best interests did not militate for returning the child.
Thank you, Ms. Mnyosi. Thank you.
Thank
Chief
you.
Justice, may I just raise one question with Ms. Mnyosi?
Yes, Justice Rogers.
This follows on from the Chief Justice's questions about discretion. As I understood your submission, because the High Court found that there was not a grave risk defense established under 13B, it was then bound by Article 12 to order the return of the child in the absence of any other defense. So the discretion, for example, that Justice van Zyl was asking you about didn't arise in the case of the High Court.
Correct. Because
the question of whether a risk is grave, I suppose one might say that the gravity question is a value judgment, but in accordance with the authorities, that it wouldn't involve a true or narrow discretion to which the ordinary rules about appellate deference apply. It was a matter of reaching a conclusion to which there was only one right answer, and having reached it, the High Court then didn't have a choice but to order the return of the child.
For the High Court, that's the exercise that was engaged, because then it took it back to Article 12.
The SCA differed from the High Court in its assessment of the evidence and found that there was a grave risk which could not be ameliorated. And you then have submitted that a discretion arises because all Article 13B says is that in those circumstances, the court is not obliged to order the return of the child, but implicit in that is that it could still order the return of the child. It simply now has a discretion not to order the return of the child. In the argument in the SCA, was there any attention given to that question of discretion, or was the case seen to turn solely on the grave risk argument? In your written, you appeared, I think, in the SCA, did you not? In the heads of argument for the two parties, was there any, was the fact that this discretion would still exist if the SCA overruled the High Court on grave risk identified? And was there any submission from your side that if the SCA found that there was a grave risk, it should nevertheless exercise a discretion to order the return of the child?
I think our argument at the SCA, we were the respondents in the appeal.
Yes, that's correct.
Yes. Our argument in the SCA was that if the SCA indeed found that there was a risk, the risk was not grave, because the Article 13B defense was not established, and therefore we were arguing for it not to engage a discretion at all and to still remain within the parameters of Article 12, because our argument was that
No, I understand that you were defending the High Court judgment, but did you put up in argument a fallback position that if the SCA overruled the High Court and found that there was a grave risk, that nevertheless the SCA should then go to the next step, the discretion, and should exercise its discretion against ordering the return of the child?
I don't think we posited that argument, Justice Rogers.
And I don't see it featuring in your application for leave to appeal to this court. Assuming the SCA's conclusions about grave risk and the fact that there were not ameliorating mechanisms which could sufficiently neutralize those risks, do you in fact argue that there was nevertheless a basis on which the SCA should in its discretion not have ordered the return of the child?
Our argument in relation to the SCA, Justice Rogers, is had the SCA considered the full conspectus of the evidence and the principles, the SCA had no reason to depart from the decision of the Western Cape High Court. That was the sole purpose of our argument. We didn't do an alternative argument.
And in this court, then I assume your position is the same. You don't seek to persuade us that if the SCA was right on the question of grave risk, we should nevertheless say that it ought in its discretion to have still ordered the return of the child. That's not part of your case.
What we say, Justice Rogers, is that this court should engage in an exercise of revisiting the test for deciding graveness, and what's the threshold in terms of evidence for deciding graveness in circumstances such as this, because it has the unintended consequences of ultimately riding roughshod through the objectives of the Hague Convention.
I don't want to go back to the 13B argument. I was just focusing on discretion. I understand your answer, but I take from that it is not part of your case then that if there was a residual discretion, if grave risk went against you, that the discretion should have still been exercised in favor of the return of the child. You think this case should turn on what we conclude about the existence or otherwise of grave risk?
Those are our submissions in that regard, Justice Rogers.
Thank you.
Thank you, Ms. Mercy. Just one final thing. Subject to what you might say and what counsel for the respondents might say, my understanding would be that if the determination of whether the risk was grave is a value judgment, which I prima facie think it is, then the limitations applicable to a discretion don't apply. And an appeal court would be at large to make its own assessment whether the risk was grave. If that is correct, that would mean that the Supreme Court of Appeal would have been at large to make that assessment, unlike if it's a factual finding. But just as the SCA would have been at large to make that assessment, this court would also be at large. That is, if it's a value judgment. Is that understanding in accordance with the law as you understand it?
It must be informed by that principle, Chief Justice. If you look at the balancing exercise of long and short-term interests that was described in Sonderab versus Tondeli. The balancing exercise allows that kind of approach in ultimately.
Okay, thank you, Ms. Mayosi. We are at 25 to 2. We have two, maybe three options. One option is that we take the lunch break now. Another is that we allow counsel for the respondent to address us for 30 minutes, and then we take the lunch break at 2:05. Colleagues, have you got a preference?
CJ, how can I ask for a break, a lunch break now, or at least a short comfort break, if not a full lunch break?
Okay,
Please.
well, maybe if we are going to take a break, we may as well take a lunch break, but maybe we look at 30 minutes rather than an hour. Is that correct?
Yes.
Agreed, agreed.
Is that fine, colleagues?
Agreed, CJ. Thank you.
So maybe we should take the lunch break now then, if
Yes.
colleague needs some time. Is that fine with counsel as well?
Indeed, Chief Justice, thank you.
Indeed, Chief Justice.
Okay, all right. Thank you very much. We will take our lunch break now, and we will return, let's just say 2:10, because I'm going to ask that the technicians take counsel and everyone else out. I remain with my colleagues to discuss something for 5 minutes before we go on lunch. So we will then adjourn the proceedings now until 2:10. And Mr. Naidu can then take counsel out and other people, and then I remain with the justices only. Thank you. The court adjourns for that purpose.
Court will adjourn until 2:10. Please note that during adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin video and sound when the hearing recommences at 2:10. Should you exit, you may use the same link to rejoin the hearing.
I see Ms. Castle seems to be still there. Zunate, is it only us now?
Chief Justice, please bear with me.